Well, good morning, everyone. As you said, my name is Stellmach Freiert. I am an attorney with Amundson, Boggio, Hendricks. We are a law firm in Richfield, Minnesota that focuses solely on elder law. I also have had a lot of coffee this morning, so if you say, hey lady, you're going way too fast, I have a lot of information, wave at me, I'll be happy to slow down. I saw that there are a lot of questions in this group, which is awesome. We've reserved some time at the end of my presentation, so while you can definitely let me know you have questions along the way, I may say, hey, we're gonna get to that. But we're talking about feeling prepared. Oh yeah, there's me. Talking about feeling prepared in the new year. What does it take to be prepared? What are some of the documents that you should have in place, or we think most people should have in place to be prepared? And actually before that, what is elder law? Okay, so I know what an estate planning attorney does. I go to them, they do wills, you know, all of that stuff. What makes an elder law attorney different than an estate planning attorney? Well, I still do estate planning. I do wills and trusts and healthcare directives and powers of attorney. But we also do, as part of our long-term care planning and our life care planning processes, we walk with families, with individuals over a series of months, over a series of years, looking at what does this person need from a more holistic standpoint? What do they need in addition to documents? Do they need some options in their home? Do we need to start pre-looking at placement options? Are we in crisis? Has something happened and we need, we actually have a staff social worker, her name is Cindy Johnson in our office, who works with our families what questions do we ask if we go tour a facility? What do we need to who are some resources? We're looking at this area of the metro, what would be a facility that you would recommend that meets my X, Y, and Z criteria for myself or for my loved one. So that's a little bit I know it's not a straight answer, but I'm an attorney. We don't really do straight answers. I'm sorry. So who needs to plan? I'm obviously going to be up here for about an hour. The 5-minute or 5-second version is if you are over 18, you need to plan. Once you hit 18, nobody can legally make decisions for you without getting the court involved. I'm an attorney. I don't like going to court. I am the paper type of attorney. We have 3 attorneys in our office who do nothing but litigation. Bless them, but that's not my thing. So if I can keep us out of court by doing planning, by preparing, by putting those documents in place before they're needed, that's my jam. So are you over 18? Are we looking at maybe estate taxes? Right now I'm more worried about Minnesota. I don't know how many of you tracked how closely all of the tax law changes that came out towards the end of the year, effective this year. But essentially, for federal purposes, you can have $11.2 million for you and your spouse each, and we're not worried about taxes. So we don't worry too much about federal right now, but we're looking at Minnesota. You know, if we're ballpark between $2 and $3 million, we might need to start talking about planning for tax purposes. And I apologize, but I didn't memorize the order of my slides. And so I'm going to hold this so I'm not stuck, because I also don't stand still very well. Blame the coffee. Do you have a family member with special needs? If we want to leave money for someone with special needs, or if there are other options, we want to think about that in our planning. If you have real property in more than one state, I know especially this time of year, we're getting sick of winter, we consider getting that condo in Arizona or Florida or somewhere else. If we have property in more than one state, we have to start looking at administrations in more than one state. A trust might be a good option, or a will, or depending on all sorts of things. Are you gonna say, forget it, I'm done with Minnesota forever and I'm moving away? That's a whole separate conversation. Did you recently get married or divorced? Marriages, divorces, things like that impact your estate planning. Maybe you did a will how many odd years ago when your kids were about yay tall to make sure you had guardians in place and you never looked at them again. My guess is their needs and your needs have changed a little bit in the meantime. I also told a room of 80 Catholics at one point to live in sin rather than get married again for medical assistance purposes in front of their priest. Kind of not my best moment. But the priest very nicely took it in turn and said, well, you know, confession is at 4 o'clock on Saturdays, so he at least was a good sport about that one. Do you have children from a prior marriage? We get a lot of questions of, well, can't I just go online? Can't I use one of those programs and won't it give me what I need? Well, that's an option for some people, but if you're on a second marriage, if you have children from different marriages, if you want to leave money to someone other than the person you are currently married to, that may not plan out the way you want. One of the things in our office, when we start working with someone calls our office, we send out a planner and we say, okay, we want all of this really nosy information. Tell me about you, tell me about your spouse, tell me about your kids, tell me about your money. How much is coming in, how much is going out, what is saved where and how and whom and who's titled on it. There is a rhyme and a reason for it because we're trying to figure out what works if we have tax considerations, if there's other things we're looking at, and where does it go? With that is also the nosy question of, do your kids get along? Do your kids and their spouses all get along? Is there a pot stirrer in the family that is going to maybe dig up trouble if one of you are ill or incapacitated or when you die? I'm sure you've all seen grief and money do some really interesting things to people. Families fight over, what is the seminar, grandma's yellow pie plate or something like that? Families can be interesting. Do your retirement plan and estate plan lack coordination? We'll kind of talk through some of the main ways that assets transfer when you die and what might be a good option, but if your retirement plan beneficiary does not line up with what your will says, things may not go where you want them to go. And do you have a diagnosis that may require long-term care? We all know care is spendy. It's getting more expensive each day. And so there are some planning tools that we can put in place. But kind of laid out what the common planning techniques are, and we have our two couples, and the first are, pointing fingers at each other. Well, you were going to do it. No, you were going to do it. No, you. And they basically end up at the end of the day doing nothing. They own property jointly. So, well, we have our house and our bank account joint. That's good enough. They have beneficiaries on their accounts. They've done a will. Maybe they've done a trust, powers of attorney, advance directives, or transfer on death deed. These are kind of all options, and we've seen everything in between come into our firm. So, the do-nothing option, estate of Prince. I don't know how many people have tracked it, but it's, a year and a half later, and it's still in court, and there have been multiple subsequent litigations happening over attorney's fees and over who is involved and over this and over that. This was not someone who should have done nothing. While I don't know any of you personally, but I'm guessing your assets may not be quite that sizable, it's still not a reason to do nothing. Without any kind of plan in place, it guarantees that we're going to the probate court. So probate is not a four-letter word in Minnesota, but it does mean a time-consuming process. We have to file documents with the court. We have to wait a statutory period. There's a lot of stuff that has to happen. And if you don't do a will, you don't have any planning in place, we follow what's called the Minnesota Laws of Intestacy, which says, well, we look at your spouse, and if you have joint children, then we look to your kids, and then we look to parents and the descendants of your parents, so your siblings, and then your nieces and nephews, but I don't want my sister to get anything. Well, then we better put a plan in place. You have no control over what happens if you don't do anything, which is where we like planning. So one of the easiest things is to own property jointly. I am married. My husband and I, clearly, we're in our 30s. We don't have a whole lot right now, but we have a 13-month-old. Well, we own our house. Well, actually, we don't. But we're buying a house, and that house will be joint. It's easy. It's a game of survivorship. Last man standing. My husband dies. It all comes to me. I'm the surviving joint owner. Again, it's easy. It's free. It's not subject to probate on that first death. My husband dies. It comes to me. Well, that's great, but what happens when I die? Or what happens if we're in that rare circumstance that we're in the car accident together, or we're on the Titanic and it goes down? And with that comes the downside. It's not controlled. If I die, I don't necessarily, right now I want it all to go to my daughter, but if she grows up and becomes a pain in my backside, I might not want her to get my assets. It avoids probate on that first death. It doesn't avoid taxation. So if our house, it's not, but let's say we own a $5 million house. Well, there's a potential I would need to pay some estate taxes on that for me to inherit it. Can create unintended heirs. Again, we're talking second marriage. I have my kids from a first marriage. My husband has his from a previous marriage. We get married and buy a house together and it's joint. Well, if I die first, I want to make sure that my kids get something. If it's joint and my husband gets it all, it might all go to his kids and my kids might not get anything. And it doesn't plan for joint tenancy properly. So again, we're looking at what is that succession down the road. So kind of the next tier. So we have do nothing, we have that joint tenancy, and then the next tier of how things kind of distribute between people are by designating a beneficiary. So we can call them a payable on death, we can call it a beneficiary, we can call it a transfer on death, a POD, TOD, those types of things. A lot of the terms are interchangeable, it just depends on what type of asset you're talking about. But if I use any of them, I mean the same type of thing. So when we're looking at your work 401k plan, your IRA through work, life insurance policy, a bank account with a payable on death, transfer on death, an IRA, you can name who you want that to go to. We usually say, okay, here's who I want it to go first. I want my spouse first. My daughter's 13 months old. I don't really want money going out right to my 13-month-old. Mind you, it wouldn't. It'd end up going to court and we'd have to get a custodian and all sorts of other crazy things put in place. But maybe, again, here we're looking at a second marriage. Well, I want my spouse to be able to use it, but if my spouse doesn't survive me or upon my spouse's death, anything that's left or I want to go to my kids, this might not be the best planning tool. It is, again, an easy way. Using a beneficiary designation, we avoid the probate process. It's outside, it just transfers. Again, does not avoid estate taxes. If I have multiple large investments in stocks that have done great and I have to pay estate taxes, regardless that it's transferred to my beneficiaries, they may still have to find a way to pay the estate taxes on it. Also, this does not have to necessarily be done with an attorney. However, done in conjunction with a conversation is usually the way this works. When you meet with someone in our firm, we kind of talk through, okay, here's what the plan is, here's what we're going to do. You're going to contact your company and get a change of beneficiary form or verify that your beneficiaries are like this, mostly because those companies don't want to talk to me. They're like, who are you? How are you involved in this? Do you have a power of attorney? Can you talk to this person? We don't even know if they have an account. Every now and again, they'll give more information than they should, but most of the time, they only want to talk to you. Problems, again, may not protect your spouse. If we're dealing with a situation, I work with a lot of families where we have one of the couple is looking at needing care. Well, if they're the primary beneficiary and we've been trying to qualify them for benefits and the healthy spouse who has a $100,000 IRA dies and it says it goes to my spouse, well, all the money we've just impoverished them with so they would qualify for medical assistance, for instance, now they have another $100,000 that they have to spend. So that may not be the person we want designated as the beneficiary. Does, again, not protect and care for children. I don't want my 13-month-old getting my IRA. Can cause unintended beneficiaries of, especially when we look at employer-related plans. Most employer plans, if we're looking at an IRA, a life insurance policy that's paid for by an employer, even if it follows with you after you have retired, they have some pretty specific rules if you don't designate a beneficiary. So let's say the beneficiary that you named when you signed the policy 30 years ago has died. They then look, sometimes depending on the contract, and you have to stupidly read all of the contracts, it'll say if you don't name a beneficiary who gets it under their plan. Again, minimal control. So who needs a will? Well, I don't have anything. Just me and my husband, and our house is worth about what we owe on it. And at the end of the day, when you pay for a funeral, we probably don't have that much. This is in my hypothetical. Do I still need a will? Well, right now, yes, because I want, a guardian for my child. But let's say she's grown and I'm whatever age. The bonuses and the good things about signing a will, they're easy to establish. You sign a will, you figure out kind of what you want to have happen, who's in charge, who gets the stuff. You sign it, you put it in your safe deposit box or your firebox, and you forget about it. And it does its job. This is also why we ask some really ugly questions when you meet with us of, okay, so if your child predeceases you, does their share go to their kids, or does it go to your other kid, or does it go to a charity, or who does it go to? We ask some really ugly questions like that and hypotheticals that kind of trail down so that if you never do another will, this should still follow at least what you wanted at the time that you did your document. It is simple. It's kind of a one and done. You have a meeting to talk about it, you review a draft, you come back and you sign it, and again, you don't look at it again, we're okay. It creates certainty. We know who your beneficiaries are. My brother is a couple years younger than me. He has a 4-year-old, and my nephew is 2 months younger than my daughter. They don't have wills. And there's me and my husband, and then I have my sister-in-law has 2 siblings who are also married with children. So we're like, who do you want to get the kids? Likewise for beneficiaries. If you have someone you want to receive everything in an unequal share, or you want someone to not get anything, putting that in a will is a way to make that happen. The other benefit is we don't need to retitle assets. So when we talk a little bit about trust, we talk about having to put things into the trust itself. With a will, you don't. We just leave it as it is. We make sure your beneficiary designations line up with your will, and we leave it. Now, some of the downsides, it doesn't plan for a disability. Again, when we're looking at that husband and wife and maybe one of them needs care, well, we may not want to leave all of the assets of the healthy spouse to that ailing spouse if the ailing spouse is already qualified for benefits or other things like that. It doesn't take those factors into consideration. It requires a probate administration. Again, not a four-letter word, but it takes time and money and effort. Requires publishing notice with the court. So when someone dies, we publish notice that they've passed away, here's the probate, here's who our personal representative is. And so there's a little bit of loss of privacy because court records are public. Your will gets published into the court record. So if you are specifically omitting someone, you might not want that out there. And it can be more expensive than using a beneficiary designation or using some trusts. So what is trust? Well, I'm kind of thinking of it as a suitcase. We fill it with all the things that we need or may not need, basically all the things we have, and it holds. I can take my suitcase and I can hand it off to my heirs, I can hand it off to my spouse, I can hand it off to my best friend for the benefit of my child, and it transfers it easily that way. It is fairly easy to put stuff in and out. The downside is we do actually have to put stuff in and out, which means changing the ownership or changing the title or changing the beneficiary on some things, which is paperwork. I don't hate paperwork, but I know some people kind of run very, very fast, far away from paperwork. Trusts are managed by a trustee. Most of the time when you set up a trust, you are going to be the individual who's putting the stuff in, so you're the settlor or the donor, and you're also the trustee, you're the person who's managing it right away. But then we kind of put a hierarchy of, well, if I'm incapacitated or when I die, here's the next person in line. And if they can't do it, here's the next person in line. And if they can't do it, then maybe we look at a professional or maybe we look at someone outside of us or our kids. Yeah, my one kid, he's got a gambling problem or we've got an addiction problem in the family or we've got, you name it, we've heard the stories. This is, again, it's a safe zone. There's no judgment. I want to know these things because maybe that's a person that shouldn't be involved in your plan. And maybe we start looking at a professional. There are a number of institutions out there and individuals out there who provide these services if you can't think of someone or there isn't someone in your immediate family or friend group that you would trust to do this for you. Because this is access to your money. This is a big deal. I know I'm talking about it kind of glibly, but this is your livelihood. This is everything you've worked for and saved. Trustees, again, can be replaced due to death, change in circumstances. As long as you have capacity, you can also change your mind. So if you've named someone in your document and they later become untrustworthy, life happens, circumstances change, we are not as close to some people over time, you can always come back and amend that and take them out. One of the benefits of a revocable trust is we can plan for disability. We can say that, you know what, in my lifetime, if I become incapacitated, or in my lifetime, if it looks like I'm going to need skilled nursing care, here are some things that can happen. We can put parameters in place as to what happens in each of these triggering events. These cross state lines. So when we prepare a will, or at least when I prepare a will, I'm only licensed in the state of Minnesota. So I prepare a Minnesota will. Most states have kind of a reciprocity. They'll look at wills from other states as long as they meet in Minnesota, it has to be signed in front of 2 witnesses. It has to have certain things involved in it. If it meets that criteria for another state, they may accept it. Trusts, it doesn't matter. You can take it with you. You can spend half of your year in Florida, Arizona, Europe, wherever you want to go, and it's still gonna follow with you and be okay. It's private. Unless people start fighting or unless there's a question about your trust, we don't have to go to court. We can do it all outside of the trust, and it protects your family. We can say that things continue in trust. If we have a kid that doesn't do well with money and we're worried if they get an inheritance, they're gonna blow it all right away, we can say it continues in trust for their lifetime. We can put somebody else in charge. I don't usually recommend putting siblings in charge of each other's money because that's not a good way to keep family harmony. Some people have told me, no, it'll be fine. I'm like, can we put a backup, please, in case that child doesn't want to be their brother's keeper? Because I don't want to be mine. Thankfully, he does great. But it also is a way to protect things for remarriage, for creditor protection, and for tax planning. When we look at remarriage, we can put in provisions that, you know what, I'm married now, and I want it to go to my spouse, but I want it to stay in trust for my spouse, and if my spouse ever remarries, they don't get full access to this anymore. Then someone else gets to sit in place unless there's a prenup saying that anything left in here goes to my kids. Because I want to make sure. And while, I love and trust my spouse completely, I don't know who the next little, pool boy or cabana boy or drink girl is going to come through when he's sitting at the seniors resort in Arizona and turn his eye. And again, tax planning is a means that we can look at depending on where your assets are at. Is this something we need? And make appropriate planning to minimize any taxes that your estate might owe. The documents that we usually talk about, so again, the snapshot version, anyone over 18, will, power of attorney, healthcare directive. Power of attorney is a financial bill paying power. So this is the document that says, I give you the ability to step into my shoes. You can access my bank accounts, you can pay my bills. To a certain extent, it's a license to steal, so we think about a lot who we're putting in place here. It's limited to financial powers. So once upon a time, well, not once upon a time, but a decade and a half ago, they were called powers of attorney for healthcare directives as well. Those are now called advanced directives or healthcare directives. We'll touch on those next. This is solely a financial power of attorney. It says, this is the person stepping into my shoes. We do not do springing power. I get a lot of, I only want it to be effective if I become incapacitated. Well, the problem is no one wants to determine that you're incapacitated because that's a liability on them. So we prepare what's called the Minnesota Statutory Short Form Power of Attorney. It is effective when you sign it, but it has to be an original. So you just don't hand over the original. You hold on to the original and say, hey, brother, if I'm incapacitated, go look in, the firebox in my bedroom closet and pull out the power of attorney and use it. I don't hand it over right away. It can allow gifting powers, so you can decide whether or not your attorney, in fact, has the ability to gift your money to you. Why or why not you may want to include that power is where in our planning. If you're 18, we're probably not talking about gifting powers. If you are 70 with a diagnosis, if you're 85, if we're looking at maybe there is a long-term care planning thing and we might be working with your attorney, in fact, to qualify you for benefits, then maybe we want to do gifting to maximize options later. Powers of attorney die with you. This is the other one. I get people who call and are like, well, I was so-and-so's power of attorney and they're dead and they won't let me access the bank account anymore. The power of attorney dies with you. You sign it, it carries with you, you die, the power dies. That's then when we look at your will or your trust to pick up and carry on the next proportion. The other thing with a will, just because you're nominated in someone's will doesn't mean you have power right away until we go to the court. So that's the other question we get a lot of. Well, I'm nominated as the person representative, as the executor in this will, but the bank won't let me do anything. Well, that's because we have to file the probate and we have to have the court say, yes, I see that you're in the document and yes, you are actually qualified to serve and here's the document from the court. They're called letters testamentary that say that you can do that. My big watch out, again, it's a powerful document. It's almost a license to steal depending on what you've set for gifting powers. So, does the person you're looking at appointing have substance abuse issues? Are there trust issues? Are there any financial issues? Do they gamble? Do they have a high-risk job? Are they in a position? And they may not be. And again, this can change over time. But every now and again I get well, I have to put my son because he's the oldest and he's going to expect that he gets to do this. No, I'm happy to be the bad guy in that situation and say, no, daughter is closer or this is closer. Those conversations are confidential between us. It means I occasionally hear things that I wish I didn't, but I am a safe place. I can't tell anybody what you've told me, but I can be that black sheep, the person that says, yeah, that's really not a good idea. If, so-and-so has filed bankruptcy 3 times, we probably don't want them accessing your finances. The third document, wills, power of attorney, healthcare directives, is appointing someone to make those medical decisions for you if you cannot. It gives them also the ability, they're nominated in a hierarchy. So my husband gets to make my decisions. If he can't, then my best friend does. And if she can't, then I'm looking to my parents. Mostly because I know my best friend knows my wishes a lot more than my parents do. I've had my conversations with her a lot more of, pull the plug, I don't want to be that person. And I think she would probably do it a little bit easier, not easier. She would more willingly do what she knew I wanted than my parents might. And when we look at things like this, I always use the examples of Carrie Quinlan and Terry Schiavo. Those are kind of the most public ones of people who didn't think they would need a healthcare directive. They were young, and all of a sudden without that, we have spouses and parents and other family members getting involved in fighting for who gets to make the decision, all the while this person is sitting on life support who may not have wanted to be on life support in the first place. So this is one of the reasons that in addition to doing a directive, have a conversation with the people named in your document. One, letting them know they're in your documents, because that's occasionally a surprise for people too of, oh, I get to make that decision. Okay, that's interesting. And then followed by that, if you haven't had a discussion with them, what do they want? I don't know what they want. I mean, we put some language in, and there are some very, very lengthy healthcare directives. Some of them have, in this circumstance, yes, in this circumstance, no, in this circumstance, I want this. I'm less concerned about that. Medicine diagnoses, treatments all change very rapidly. Saying more, here's the person I trust, and having a conversation of, here's the general things I want to have happen, here's how I want you to care for me if I can't communicate what my medical wishes are, is much more important and valuable. I will occasionally, this morning I had a couple and their adult children came with to their signing appointment. And it was like, have you guys actually had that conversation? The spouse, one of the spouses is looking at some potentially life-threatening treatment that's going to be coming up, and she's appointing her son. Like, have you told him what you actually want? Because if you haven't, I would start doing that now since you're having a procedure next week. This would be a good time to have that conversation. Again, choosing agents carefully. I pick on my best friend's family for this. Her sister has said, I will never pull the plug. Don't make me do it, I will never do it. So she's not on her parents' health care directive. She's the financial person. She's gonna pay all the bills and make sure all that happens, but she won't do it. And so her parents very justly said, okay, we won't even put you in that position. We can also decide whether you want to be an organ donor, if you want to be buried or cremated. Do you want heroic measures in the event of a persistent vegetative state or a life-threatening illness? And then we include a HIPAA designation. So who can actually speak to your physicians and get that information to make a smart decision? I touched on this a little bit more, but in addition to that planning, we're talking about it's a new year, what do we do to plan? We're not just planning for your death, we're planning for a good life. We're planning for how do we get you to have the best life possible from here to the end. Because we all have an end, we just don't know when it's gonna be. So when we look at life care planning, we're looking at that holistic approach. We're working with an elder law attorney and our staff social worker who is our life care coordinator, and we're looking at not just the financial and legal stuff. I mean, we do that. We make sure your documents are in order. We make sure all those pieces are in place. But what else do we need to have a good life? When we're planning for benefits, if we're gonna spend a whole bunch of money to qualify for medical assistance, so what do you need to be happy? Does this mean we're going to take one heck of a great vacation now as a family, or does this mean we're going to get you a new car because you've been driving the same car for the last 20 years? There's a lot of things that we talk about that go beyond the nuts and bolts of sign here and who gets your money and who's in charge. It's not the process that is kind of outlined here, and I apologize, the colors aren't quite clear as they're on the screen, but you meet with the attorney and you meet with the life care coordinator, and we go through kind of what you want, some financial planning and estate planning, and we create an action plan. And then 6 months later we follow up because not everyone is at a point that they need to do planning the first time they come to see us. We may be years out from actually needing to do anything. Well, okay, let's touch base in 6 months, or depending on where we're at in the process, we're gonna touch base in a year, or we're gonna touch base in 18 months. And we kind of set when that follow-up is gonna be. Now, that's when we've scheduled it. But life happens, and we don't have crystal balls, we can't plan. You give us a call, hey, something happened, we need to meet sooner. That's not a problem. This is just our ever-changing. It's also kind of in a cycle here because sometimes we come back into the middle. It's not always gonna be the circle out and out and out and out and out. Sometimes we jump back a couple steps. Sometimes we have to revisit things. We talk about veterans benefits, benefits through the Veterans Administration, benefits through the Veterans Home. We talk about medical assistance benefits, benefits through the county, things that can be done in your home, in an assisted living, or in a long-term care facility. If we need to, we do annual assessments. We do applications for those benefits, and we continue to have those follow-ups through placement, if necessary, and then even after placement to make sure that our plans are still working. Some of our plans involve bringing in children and other family members and loved ones to be a part of this plan. Well, we also want to make sure that they still understand, because sometimes when we're in the middle of a crisis, and obviously I talk a lot, you're only going to take, this small amount out of everything that I've said. Well, who's going to remember that 6 months later? Who's going to remember that a year later? This is what I talk about day in and day out, making sure that we're following up and everyone's still on the plan and everyone remembers why we did this and what it's for, is an important part of our life care planning process. As a part of that, we talk also about long-term care planning. So that's when we're looking at, we need some help. How do we plan to keep us both at home? I hear from most people, I want to stay in my home until I die. I'm going out that door feet first and this is the plan. Well, that's great, but what if that isn't an option? So let's start with, what do we need to do to stay at home? Okay, well if that's not, do we look at skilled nursing, or I want to stay home, but I can't stay home without my spouse, or how do we plan for all of these things that we don't know what's going to happen, but I'm not a lot of fun to have at parties. I talk about worst case scenarios. So I'm like, here's our best case scenario and here's our worst case scenario, and we're actually going to plan for this and hope that it never happens, but if we don't have a plan, that's what's going to happen. We talk about end of life decisions. Those are really hard for a lot of people. There are some people, one of the shareholders I work with is very, very blunt and very forthcoming and says, this is exactly what I want, and you're gonna turn me into cremated remains and make me out of it into a little diamond. You're gonna give it to your spouse. Like, she has some very entertaining options about that. It's not as easy. People cry in our office. That is okay. I might cry with you. I blame the baby, but it's probably just me. We talk about how are we going to pay for this? So we have all the things that we've saved our whole life. We don't want to spend it all. We want to leave a legacy for our kids. We want to do. That's all part of this planning process, including that spend down of assets and how we do it. I'm not going to talk a lot about medical assistance because I can talk for well over an hour just about medical assistance, but I will touch on it here because the other thing people come to talk to us about is asset protection. Well, me or my loved one is sick and we want to preserve assets. We want to make sure there's a legacy. We want to do this. We want to make sure that there's enough for the healthy spouse or for the other spouse or for whomever to continue to live. The farther out we are from a crisis, the more options we have. If we're planning in crisis, there are some options, but they are far fewer than when we are a year back, 2 years back, 3 years back, depending on where those assets are. But that is something we talk about within our firm when we look at your specific circumstance. I wish I could say there's a blanket coverall of this is what everyone needs to do, but I can't, because you all have different wants. You have different people you want to leave things to, or people, not people, but charities or other things that are based on your personal interests. So there is no one-size-fits-all plan. So again, we kind of talk about how do we pay for care? We have someone in our family, we have a loved one, we have a parent, we have a spouse who needs care. We can always use your money. And that's great to a point until we can actually qualify for benefits. That's one of the things that I do is start looking at, okay, here's where we're at, here's how we can best use your assets to get the most care. Using Social Security income, if you have long-term care insurance and you can continue to afford the premiums, long-term care insurance is a great asset for a lot of clients. If those things have run out or if we've gotten to other assets, then we look at medical assistance benefits. Medical assistance benefits through the county, the state, and the federal government will require that you be impoverished to a certain point. They want you to spend your money on you before they're going to kick in and care. Veterans benefits are a little bit different depending on when you served, how long you served, and how you were discharged. Veterans benefits are available for both you and the spouse of the veteran. So I get a lot of people too of, oh, my husband served and I'm entitled to that, or vice versa. Yes, if your veteran hit the criteria, the spouse is also eligible for those benefits. When we are dealing with someone with special needs, we can talk about trusts, we can talk about pooled trusts. There is a big kind of, it's getting better, but people kept saying, oh, I need to put all my assets into a trust to protect them. Not necessarily. A trust is not necessarily going to protect your assets. It may not be the right tool for you. So someone saying you must have a trust, ask them why. What are the criteria of your specific situation? Because it may not preserve your assets for medical assistance purposes, especially if you haven't created it more than a decade ago. And then ABLE accounts are achieving better life expectancy. They are a tool for financial planning for someone who has been certified disabled before the age of 26. This is kind of an evolving area. It's come out in the last 4 years in Minnesota, and we are really excited to have this as a planning tool in our arsenal when we are working with families with individuals with disabilities. Medicare versus Medicaid. I get a lot of people who say, well, I'm on Medicaid or I'm on Medicare or I'm on this, and they start interchanging the terms. They are actually two separate programs. So Medicare is the federal health insurance program for people over 65 years old or younger people who have certain disabilities or end-stage renal disease. This is an entitlement program that you pay into through your Social Security as you've worked, or retirement benefits through the railroad. You have to work at least 40 quarters to qualify for Medicare. Medicaid is Minnesota's medical assistance program. It's a social health care program for families. This is means tested. So that's, again, do you qualify based on the assets you have and based on your financial and health needs to get Medicaid benefits? So when we look at Medicare, we look at someone who has fallen, broken a hip, has gone into the hospital. Medicare is going to cover those first 20 days in full. Well, then we transition to the transitional care unit. Medicare is going to cover another portion for the next 60 days. And then that's when we start looking at Medicaid. So we had someone who maybe it's not a broken hip, something else happened, there's a stroke, you name the diagnosis, and they're not going to be able to return home. And we need to figure out how we're going to pay for care from now until the end of their life, which could be 6 months from now, it could be 2 years from now, it could be 10 years from now. There are a lot of things that happen that we don't know with any certainty what that's going to look like. We use those two together. So we start with Medicare, and then we look at Medicaid once we are financially eligible for it. When we look at that, we have to figure out how we're going to get in between. So are we going to use your private assets to get you to that point? So are we using your IRAs, your retirement, your savings, anything else that you have as assets? If you're a veteran, are there other benefits that we can use to stopgap and get us in between there and potentially not need medical assistance benefits? And then finally looking at medical assistance. So long-term care covered services for medical assistance are skilled nursing facility. This is the nursing home. This is where nobody wants to go. There are still options here. There are options when we're working with medical assistance. To be there, you have to have a skilled nursing need of care. So I occasionally work with people who have basically just run out of money. Well, if you don't have a medical need, you don't necessarily qualify for medical assistance. It's not just because you financially hit the point. We also need to look at that. I also start talking about some of the services under home and community-based waiver. So we have things, especially when we're working with over 65s, we're looking at the elderly waiver program. So it is cheaper for us to keep you in your home and have people come to your home. This is a win-win. This means you get to stay in your home. We bring in services. The county covers part of that cost, and we've met that waiver program. If you are under 65, we're then looking at CADI or some of the other waiver programs, all which have the same eligibility criteria as medical assistance. And here's just another, you guys don't need all of these. I get a little into depth, and I also deleted out a bunch of slides because I realized I had about 70 slides to come and talk for an hour, and nobody wants to hear me talk that fast. And I am that presenter who wants to get through all of the slides. But medical assistance eligibility and long-term care in Minnesota. So we have a medical need. We have someone either in their home or in a skilled nursing facility who is getting to a point of running out of money. In order to be eligible, you have to be a Minnesota resident. That can be recently moved to Minnesota. It doesn't have to be someone who has lived here for their entire life or the last year or however long. They have to be blind, disabled, or over 65. Again, we need to have that nursing level need of care. It can't just be, I'm getting a little forgetful, but I have no other things, and I'm still paying all my bills on time, and there's a lot of criteria that go into it. And then the financial eligibility rules. For elderly waiver. So this is to get services in your home. Again, you have to be a Minnesota resident, over 65, a nursing level of care. We do that with a long-term care consultation. So we have the county actually come out and do an assessment to see what they think your level of need is going to be. And the cost of those services, and here's kind of the kicker for some families, is it has to be cheaper for us to pay for you to be at home than for you to be in a skilled nursing facility for us to qualify for elderly waiver. So if it's going to cost $10,000 a month to keep you at home and bring services in to pay for you at home, they're going to say, I'm sorry, the average cost is $7,000 in a nursing home. You're going to have to go to a nursing home if you want us to help you out. We also have to have a 24-hour care plan. So the county isn't going to send someone out to stay with you 24 hours a day. We need to make sure that there's someone else there, or there's a plan in place to make sure if you are receiving benefits under elderly waiver that you are going to be safe the whole time you are there. The big one, I'm not going to get into all of the nitty-gritty rules of medical assistance, but the big one is gifting. We cannot have made any gifts within 5 years of applying for medical assistance. That's what the letter of the law says. That's birthday gifts, that's Christmas gifts, that's wedding gifts, that's any of those things. The county will look at that as any gift was made was for the purposes of qualifying for medical assistance. Now, there's a couple of exceptions to that. We can transfer anything to your spouse. So, generationally, we have a generation where a lot of times the husbands were working outside of the home and the wives were home. So the husbands have big retirement accounts and the wives have their Social Security income and, a savings account and some other things, but the husband has greater assets. Well, the husband needs care and we're going to be moving him to a skilled nursing facility, we can move his money to the wife. Now, there might be some other tax ramifications, but it isn't a gift for the purposes of medical assistance. We can move any money between those two spouses without issues. We can also transfer money for the benefit of or to a disabled child, so to a special needs trust or to a supplemental needs trust for the benefit of a disabled child of any age, but they must be certified disabled either through the state of Minnesota or through Social Security. There's a couple of other things. The biggest one is that bottom one, a pattern of gifting. So if you've been giving the same amount to your church every week or every month for the last forever, that's usually not an issue. Now, once there is a need for care, if you're continuing to give $500 a month to your church or $5,000 a month to your church, then we need to start talking because that's not quite going to fall under the exception. So what happens if all of a sudden I've spent all my money, I need care, and I'd made a gift? What happens then? Well, then we calculate what's called a period of ineligibility. We look at any of those gifts that were made within that 5 years prior to applying for medical assistance, and we divide it, by the state average payment for skilled nursing. So right now the divisor is $7,106. If we made a $14,000 gift, because that was what the exemption was. So prior to this year, you could give $14,000 without having to report it for gifting purposes. What the IRS says you can gift and what medical assistance says you can gift are two very different things. I've occasionally had this woman bite clients in the backside. They said, well, right before I came in, I made this $14,000 gift. I don't have to report it. Well, no, you don't have to report it to the IRS, but we do have to report it for medical assistance purposes. We would take that $14,000 gift, we divide it by the 7,000 divisor, and you're just ineligible for 2 months. Sometimes that's not a big deal, sometimes that's a really big deal. Again, don't lie to your attorneys and your doctors. Those are the people who need to know what's going on. When you lie, we can't always help you. So how do we avoid that? Well, one is you just stop making gifts. I know that's not a palatable solution for most clients, but some of the other things that we can look. So we're in a planning process and we know that one of us is going to need care and we know that we're not going to have enough money to pay for care for the rest of both of our lives without using some public benefits. We can prepay our funerals. We can update our houses, we can pay off debts, we can pay our mortgages. This is where we look at, does your house need a roof, does it need new windows? Now, I'm not advocating for any of you to go start spending money willy-nilly outside of your normal plan or the way you would normally do that, but these are things that you can spend money on without running afoul of those medical assistance gifting rules. What's this medical assistance clawback thing? Do they get my money back? What happens? How does that work? My little black cloud there, I don't know how many of you are familiar with Winnie the Pooh and the little black rain cloud. When we have a couple and one of the spouses is receiving medical assistance, the county keeps track of every penny they spend on that person. I always think of it as a little black cloud. Every penny keeps going up and that cloud keeps getting bigger and bigger and bigger, and it follows the community spouse around. Now, they can't see it. It's not going to actually impact that spouse that doesn't need care. But upon that second spouse's death, it then becomes, I have a button, which is not going to work. It becomes that lien. So we have, don't know how clear the picture is, but the guy's looking at his huge bill, and it's attached to his house. So upon that second spouse's death, that's when we get the lien on the house. So we have one spouse who's received care, they've passed away. The surviving spouse has lived the rest of their life. They've passed away in their home how they wanted to. Now, before the kids or the estate can sell the house, we have to pay back that bill. We talk about veterans benefits when we're looking at long-term care. We're making a plan. We're knowing what's out there and able for us. If you've served active service during a time of war or not even during time of war, there are different benefits available to you. We look at the health administration for actual just health benefits. There are non-service related pensions called aid and attendance benefits that, again, if you meet certain criteria, we can get additional income into your household. So if your unreimbursed medical expenses exceed your income, there are pensions, non-service related pensions for just solely based on your service. There's also the benefit of the state Minnesota Veterans Home, which is probably one of the best skilled nursing facilities that I've seen in my experience that I've gone into. These are things I'm happy to talk to you more about. I will actually be here. I'm going to take questions. I think I've got 2 or 3 more slides, but I will stay for 10 minutes there, and then I'm staying for lunch. So if you have questions and you don't want to yell in front of an audience, please come find me. And then here are, actually I need to update that figure because contributions are now $15,000 a year for able accounts. So if there's someone in your family with a disability that we are looking to plan, we want to make sure that they have a benefit from your estate. This is one of the tools that we can use. And so the importance of planning. Planning is knowing what your options are, how to decide when the time is right to do that. Just because you make a plan now doesn't mean you're locked in. I'm a visual person, so I figure it's the freeway out to Fargo, and we're making planned exits at, the Albert Football and maybe at, St. Cloud, Alexandria. We've got all of these different on-ramps. Just because we've made all of these plans along the way doesn't mean we have to take them now. We can change the plan later on too. I don't want to go to Fargo anymore. I want to head south. Great, we can change the plan later on. But not having a plan means we don't know what those options are. Planning is about building a team. So it is not just your medical professional and your attorney. We talk to financial planners. We talk to your CPAs. We talk to your social people. If you have loved ones, I've had working with an individual who has, the one spouse has dementia. They brought their best friend who's named in their documents to one of their meetings. And that best friend was able to say, because the spouse is saying, no, I think we're okay. I don't think we need to talk about placement yet. I don't even think we need to tour facilities yet to see where we want. And that best trusted friend was going to say, actually looked at me and said, things have been getting bad. The last 2 months have been declining a lot faster than the last year. I think you really need to do this. And sometimes having me there as a backup is that someone outside of the couple, someone outside of the family, someone outside of the immediate need can see things that someone else can't. So they are part of your team. It is not just one-on-one. It takes a village in more ways than one. And planning is about living well to the very end. The more plans you have in place, the more steps you have in place, the more options there are. I talk fast. Questions? Yes.
Remarrying.
Yes.
You have remarrying. You have the male or the female sign a prenuptial agreement. Okay, one of the two goes into a care center. That prenuptial agreement does not keep the other partner from having to pay for your facility, does it?
No, it does
And how
not.
can you get around it?
No, so they're having a prenuptial agreement protects you in the event that the two of you decide to get divorced. It says, this is what I brought to the marriage, this is what you brought to the marriage. If we divorce, or if one of us dies, this is how we do it. Medical assistants in the county don't care about that because right now you are a married living unit. This is why I told all those people to live in sin and not to get remarried. One of the planning options that we occasionally talk about is in that event potentially getting divorced. If there's a prenuptial agreement, depending on who has capacity and who doesn't, getting divorced is something we would talk about. Getting divorced doesn't necessarily mean that we're telling everyone you got divorced. It may be a very quiet, private decision between spouses or between the families that isn't advertised, and you still present yourself to the world as that person's spouse and that person's caregiver. But we look at that as an option for some people. Or you just say, you know what? We've been married for, in Minnesota, you vest into a marriage kind of like you vest into a retirement plan. If you've been married 15 years, you're entitled to half of each other's estates unless you have a prenuptial agreement in place or you've waived through other documents. You say, well, you know what, I'm just going to do it. I don't care. It's not worth it. I don't want to get divorced. That's not part of my bag. We're just going to spend the money and we're going to qualify for benefits the best we can.
That's what I was afraid of.
Angela, there's one.
Just a short question about attorneys in fact, is that right?
Yes.
Term? How does that work with other states, or if the people that you've named are in other states, is there any
No,
complication
so
with
when
that?
we're looking at who's going to serve as your attorney, in fact, it does not have to be an attorney. That is just their title. People who are out of state is actually becoming easier for people who live out of state with, the advent of all the online banking and everything else. It is not a bar. If there is someone who is in closer proximity to you physically, sometimes that's easier. But if the people that you trust are not here, well, then we look at who's available and who you trust to serve. Yes, the question was, can you have multiple? Yes, you can have multiple. The way that we typically look at it is we have a primary and two successors if you have that many people. You can also name people to serve jointly, and you can say, I've named, my spouse and my child, and they can either serve independent of each other. So they both have an active power, but they don't have to agree. They can both go do what they want. Or you can say they have to serve jointly. And there's benefits to both, depending on the circumstances. Transfer on death deeds, it really depends on who the beneficiaries are, if there's a mortgage on the house, and what the rest of the plan is. Yeah, so not every state has the ability to do transfer on death deeds, but I have used them as a means for probate avoidance in other states. There are some states that you do not want to go through probate. It is a 4-letter word in some of those states, and so yes, when they have the ability to either look at trust planning or transfer on death deed planning in other states to correlate with your Minnesota plan, that is a tool that we have used.
And I raise that because there are a lot of Minnesotans whose real estate interest in another state consists of a mineral interest in North Dakota.
Yes.
And that I think is a very handy tool for those situations.
Yeah, his comment was on, things like mineral rights in North Dakota and other real property interests in other states, and the ability in some other states to use transfer on death deeds. Those are options in some states, but not in all states. When we're working with clients who have real estate interests in other states, we actually reach out to attorneys in that state. It would be the unauthorized practice of law for me to prepare documents for another state. So I will happily call up a colleague in another state and say, hey, I have a client, how much is it going to cost to do X, Y, and Z? And they happily provide the resources. Yes.
I'm asking about when you talk about veterans benefits, how long are you given to apply for this? I mean, do you have to apply months ahead of time or
It
what is
depends,
the
yeah, so
timeline?
the timing on veterans benefits really depends on the benefit. Some of them are retroactive, things like applications. So when we look at, the most common one we look at is the veterans home. We have someone who's looking at skilled nursing care at the veterans home. There is an average of about a 1-year wait list for veterans and about a 3-year wait list for non-veteran spouses. Once we submit the paperwork, it's just kind of watching that clock. When we look at the veterans home, your name trickles up the list until you get to the top. Once you get to the top, you have 3 days to decide if you're going to say yes or no. It doesn't mean you have to move in 3 days, but you have to decide yes or no. If you say no, you go all the way back down to the bottom. You trickle back up to the top again. And if you get to the top and you say no twice, you get kicked off the list for a year before you can go back to the bottom. When we look at aid and attendance benefits, if you have met the eligibility requirements, and we submit it, honestly, it depends on the time of the year, how long it takes, but the timing for medical assistance, we have a 5-year look back. For aid and attendance, right now, there's only a 1-month look back for those benefits, so you could transfer assets, you could make a gift to your kids, and then wait 30 days and apply for aid and attendance benefits, the non-service related pension. For the veterans home, it's a 1-year look back. So there is a timing component to that in our planning. If we're looking at gifting money to kids, we're looking at gifting money to a spouse, we can actually, between spouses, move it to the day before. But if we're looking at going into the Minnesota Veterans Home, and actually right now the wait is about 10 months for veterans, well then we want to be careful when we submit an application for the active wait list and when we make a gift. But those are all things that we kind of calculate out with what your goals are and what your needs are at the time we would meet. One more question? Anybody? If not, I'm staying for lunch. And actually, Sarah and Josh, if you guys want to stand up, Sarah and Josh are also 2 attorneys from my firm who are here who can probably address a couple of your questions too. They both do this. But thank you all for your time.